Hi, everybody. Hey, my name is Ellie Fox. I'm part of the 92nd Street Y Talks team. It's so nice to see so many of you here. We're completely sold out tonight. It is my pleasure to present tonight's event, Law of the Land, the Supreme Court's year in review, alongside our longtime producing partner, FOLCS, the Forum on Life, Culture, and Society, an organization we have collaborated with for over 15 years, and this being our 9th consecutive Law of the Land. This program is also part of our Newmark Civic Life series, which is brought through a generous gift from Craig Newmark Philanthropies. Tonight, we will break down this year's major and highly contentious Supreme Court rulings with our incredible panel of experts here. Our moderator tonight, Thane Rosenbaum, is a law professor, the founder and creative director of FOLCS, and a dear friend of 92NY, who has moderated events on our stage for nearly 30 years. Before we get started, please note that we will have time for your questions, so our ushers are distributing cards. Please write those down. We want to hear from you. If you are watching at home on the live stream, hello out there, you can submit your questions too, so please do that in the chat. Lastly, and very importantly, we are offering CLE credit this evening. So if you registered for credit, please make sure you sign in and sign out at the table in the lobby just outside of the theater. You can also buy a CLE ticket if you haven't yet, using the instructions form that's on the table outside. I think it's also on our website. With that, please join me in welcoming our brilliant panel here.
Good evening, everyone. I'm Thane Rosenbaum. You know, this is the 9th consecutive year that we've hosted Law of the Land, and many of you have been here probably before. 9th consecutive year, and every year it's sold out, and every year hundreds of people watch from home. This is certainly after the pandemic when they were able to do that. And thousands will watch this on YouTube channels and various other platforms between now and next term. So the question must be asked, this new tradition of fireworks and hot dogs after the July 4th weekend and now Law of the Land, why are you here? No, seriously, I mean this seriously. The children of the Supreme Court justices don't care about the decision. They don't follow what their parents do. The people that watch C-SPAN, right, are not watching this. They're doing something else. There's something unique about the Supreme Court and people's fascination with the court. When we first started introducing this idea, we didn't think anybody would come, and yet it sells out every single year. So anyway, thank you for joining us. It'll be another really great year and an entertaining way of explaining the Supreme Court. We try to do this in an entertaining way, in a way that everyone walks out of a FOLCS event much, much smarter. So before we do, the bingo card, if you are getting CLE credit, the start code, you need a code to start and you need a code to end. I'll give you the start is MHX, and if you're at home, you need this too, MHX 539, MHX 539. If you're here, you need it to sign in on the way in and you need to sign out on the way out. All right, gang, let's introduce my friends, and they are my friends because I usually don't invite my enemies to join me up on stage. It's strategic, really. On the other side is the incredible Jeffrey Rosen. Jeffrey Rosen is the president and CEO of the National Constitutional Center. He is a law professor at George Washington Law School. He has written a number of best-selling books for the New York on law. He has served as a legal analyst and editor for the New Republic and the New Yorker. His latest book, I think, is coming out in October, is The Pursuit of Liberty, and he's really interesting and talented to watch. Jeffrey Rosen. Next is the wonderful and brilliant Tiffany Graham. Tiffany is my colleague. She is a rock star law professor at the Touro Law Center. She's clerk for federal judges. She's written a number of different articles, and she's an incredibly astute observer of the Supreme Court. Tiffany Graham. All right, everybody. I know you, both men and women, you can start swooning now. It's ridiculous. This guy. Seriously, do you know he was like Man of the Year with GQ? This is ridiculous. This guy, not you, Bill. Just don't get, you know it's not you. This guy was on Billions, the TV show for Showtime, and House of Cards on Netflix, and he played himself. It's true. He played Neal Katyal. Neal Katyal has argued more than 50 cases before the Supreme Court as both a Solicitor General and as a private attorney. In fact, he argued 1 or 2 cases just this year, and he's got a big one coming up next year, which we'll discuss. He's a professor at Georgetown Law School, an incredibly eloquent spokesperson for the law, incredibly dignified man, and enormously fun to listen to. Neal Katyal. And last but not least, my good buddy, Bill Treanor. Bill Treanor just stepped down as the dean at Georgetown Law School, where he's returning to the faculty full-time. He served as dean of Georgetown for 15 years. Before that, he was 8 years at Fordham Law School, where I was once at, and where he was my boss. And I think at some point, if you add those 2 terms up, was the longest serving law school dean in the United States. He is written widely. He's a constitutional scholar. He's got a PhD in legal history. That's rare. He's got, oh, I forgot, there are 2 books coming out. I buried that one, Jeff. Jeff's got a new book coming out in October, The Pursuit of Liberty. Don't forget to buy that. Bill's got a book coming out next October. What the hell? We're going to tell you about it now. It's The Fathers of the Constitution. Fathers of the Constitution. Now, Bill always sits next to me because he knows me a long time. And if you see him whispering in my ear, it's not a sweet nothing. He just thinks I don't know anything. And you'll see, it's not amorous, you know. It's always like, you're an idiot. Okay, let's start with this very strange year. Because there were 60 cases decided. That's low, and it's been low. We've discussed that. It's been low. 8,000 cases were considered. So do you know what that means? You know what that means? When your neighbor gets in a dispute with you and he says, I'm sick of you, I'm going to take you to the Supreme Court, you should say, I doubt it. Because in this case, only 60 cases out of 8,000 went, and the Supreme Court needs to hear your case. It's granting a certiorari. They decide to hear your case. But what did happen this year, and we need to talk about this urgently, is what's now called the shadow docket. Now, we never really made a big deal out of the shadow docket. Those are emergency appeals to the Supreme Court. They do not receive signed opinions. There is no oral argument. There are no briefs. It's like on the fly. It goes fast. And the Trump administration's sweeping executive orders inspired a record number of cases brought by the Department of Justice. I think 17 or 18 cases went up as emergency appeals that the Supreme Court ultimately heard. And so this fast-tracking method has done something that we had not actually seen before. And let's start with Neal. I mean, how precedential is this? Is this a good thing? The Supreme Court is known for being plodding and incremental, and this seems fast track. Isn't that good? Fast track? Or is this something that is emanating out of this particular court and this particular president?
So thank you, first of all, for having me. It's a real privilege to be on this panel and with you. I think it's generally not a good thing. So let me just explain what this is when we talk about the shadow docket or the emergency docket. I'll just give you one of my cases. So Kathy Harris is an official. She runs the Merit Systems Protection Board, which is an agency set up by Congress in 1978. And when Congress set it up, it said the president can't fire the head of it without good cause. And so that's by law, by statute. So Trump comes in and just fires her without good cause. He doesn't even try and say good cause. He just fires her, and he says the statute's unconstitutional. We then go into court defending her and saying, no, Congress passed this law. It's obviously not unconstitutional. We win in the trial court. And so what the trial judge says is, we're going to stop this person, Kathy Harris, from being fired. And we're going to enjoin that. So it's a legal order preventing her from being fired. The Trump administration takes an emergency appeal to the Court of Appeals saying, stop this, fire her. The Court of Appeals says no. The full Court of Appeals says no, 7-4. It then goes up to the Supreme Court in an emergency application by the Solicitor General, and the Supreme Court says, we're not going to decide the merits now, whether she should be fired or not, but it is harmful to the president not to have his people in, and so we're going to let her be fired and let Trump appoint someone else. So that's what the shadow docket is in practice, is that's just involving one person. Sometimes you have shadow docket cases, as we'll talk about birthright citizenship, that involve, whole big swaths of society.
But there were things like, for instance, the case involving transgender serving in the military. The number of the deportation cases, they weren't really deportation cases. They were stopped. The merits were decided. This was, remember, the Venezuela number. I think there's a temporary status. There was the special protections by the Biden administration for Nicaraguans and Haitians and Cubans. All of those cases were initiated by the executive orders. And then all of a sudden, the Trump administration went in. And then in the end, for the most part, with the exception of, was it Kilmer Abrego Garcia, right? That was one case where the Supreme Court said, this is the gentleman who was taken to Venezuela and brought back. So that was one case that Donald Trump didn't win, right?
So yes, so you're giving a bunch of examples, and let me just give you a little data. So when I was running the Solicitor General's office, I never sought one emergency application to the court. And indeed, over the 16 years of the Obama and Bush administrations, I think a total of 8 emergency applications were filed. Trump has filed 20 already in 6 months. It's a stark number. Now, what he would say is, well, Biden filed 19 over his 4 years. I'm 20 in 6 months. That's not that different. It is, of course, different. The administration isn't very good.
But wait, Neal, I'm sorry, just be clear. Am I right that there's still way more than both George W. Bush and Obama did in 8 years each?
Oh, yeah, no.
Right, if you added all those years.
All those 16 years, you'd have 8 applications total.
The whole time.
Trump filed, that's in 16 years. Trump has filed in 6 months, 20. Biden filed 19 over his 4 years. So the number has been going up, but it is a reaction to, as you were saying, Thane, this large number of executive orders. And so the court gets into these positions where it's got to decide these things really quickly, as you note, without really extensive briefing and the like, and they decide it without really written opinions. And so, or very short opinions that don't give any reasoning. And so Justice Ketanji Jackson has been recently very critical of this practice, saying, look, we've got to give guidance to the country as to what our decisions say. The whole point of the Supreme Court is to have written decisions and that explain fully our thinking, and we're not doing that. And so that's the danger.
Right, but also your case was a case in which there's a lot of precedent that says Congress can pass a statute that says president can't fire people, create all kinds of restrictions on the president firing people. And they just ignore that. I think they're going to overturn that precedent eventually, but they haven't. Well, we'll see.
All right. Oh.
Yeah, but this is, it's big both in terms of they're deciding all these cases without briefs and like a paragraph or two. But this is also a case in which, they're really getting ready to overturn precedent, long-established precedent, in like a paragraph or two, right? And it's part of the unitary executive. The idea that the president can do anything and court's not going to stop them. So these are really big deal cases.
So another thing that is part of the house cleaning before we get to the actual cases is something that I think a sensitive topic. And I want to start with you, Tiffany, because you remember 2 years ago you were very excited because Ketanji Brown Jackson had been appointed to the Supreme Court. I think you knew her in college. There was a reunion. You didn't show up to the reunion. You were upset. You had a fangirl feelings for her. You wanted to get photos. All your other friends had photos. And so last year I said, how did she do? All right. So this year I want to ask something else, which is that she ends this term in a flourish because there is an opinion written by Amy Coney Barrett in which she is indelicate in describing Ketanji Brown Jackson. You know, let's put this, it doesn't seem like a sisterhood. If you read the opinion, it seemed harsh. It seems like she was questioning her understanding of the Constitution and constitutional history. And so is this a dust-up? Is this something, I know that, and I had Sonia Sotomayor on this stage years ago, and she and I talked about how Justice Scalia and Ginsburg were buddies and they'd go to the opera together. And so and they didn't agree on anything, right? So that's possible. And so are people making too much of a big deal? Are they actually playing tennis when they're not squabbling? Is there a history, maybe Bill can help out, of justices throughout the history that everyone hated? This is an area that, Jeff, you may know something about, that simply they couldn't stand each other.
I mean, I will say that Justice Scalia was known for his very sharp tongue, but he was also known for being extremely charming. And so, you know, I don't know that that necessarily had an enormous impact on his relationships on the court. But I would say that there are so few of them that I can imagine that just from the perspective of being human, that they likely try to get along, but they're dealing with issues that are so important that sometimes you can imagine that feelings get frayed and harsh things get said personally, and obviously this time on paper, because the issues are so critical. And the case that Thane's talking about is the birthright citizenship case. And in that one, when you look at that dust-up between the two of them, it kind of made me think of a couple of things. One, you're seeing various members of the court are willing to mix it up with each other, even within the conservative majority at times. It doesn't tend to get that personal. This one was pretty personal and was shocking to me, but I don't know why it's happening other than perhaps the importance of the issues that we're dealing with. But what I will say is, given what actually was said, Justice Barrett essentially said that Justice Jackson doesn't really know the law that well. And Justice Jackson essentially said, you guys are hiding behind boring legalese in order to give the president the right to do whatever he wants to do. And as Michael Jordan said, she took that personally. And so what I would say about
You mean
that,
Amy Coney Barrett took that
did.
personally?
She did, yeah. So what I would say about that is it was impolite. Both sides, they were impolite to each other, but when I was reading Barrett and then reading Jackson, I kind of felt about Barrett, you know, that old cliche, a hit dog will holler. One of the things that Barrett is concerned about is the perception that the court is far too ideologically aligned with the Republican
Meaning
Party.
public legitimacy.
Yes, yes. And so I think that this spat and her response to what Jackson said is perhaps rooted to some degree in that
Quickly,
concern.
Jeff, anything about, given your own work with the Constitution, at the Constitution Center, are there sort of legendary battles between justices that we should know about?
There are, and last night we had a great Supreme Court review at the National Constitution Center. I was moderating, I was in your role, and I asked Jess Braven from the Wall Street Journal and Jan Crawford.
He was here last year in your seat.
He's just great.
He's great.
And I was in your seat, and Jan Crawford was in
That's
Neal's
how things
seat.
work out.
And at the Constitution Center, of course, I'm not allowed to have any opinions of my own, which is an incredibly liberating thing to do. And I said, Justice Jackson has just accused the majority of creating a zone of lawlessness which represents an existential threat to the rule of law. And the 6 conservatives respond through Justice Barrett that Justice Jackson's views are not rooted in 200 years of precedent and the Constitution. Who's right? And Jess Braven and Jan Crawford said that they both believe that they're right. And Justice Jackson absolutely believes that this is a zone of lawlessness, and the majority is convinced that it's Justice Jackson who's threatening the rule of law. What does history teach us? Yes, we have been here before. There have been times when the court has been so polarized that each side accuses the other of complete lawlessness. After the Civil War, Congress literally reduces the size of the court to prevent Andrew Johnson the ability to make any appointments. Then Grant comes in, they give him 2 more seats. He appoints 2 judges to overturn the Gold Clause cases, which is the Roe v. Wade of its day, and having just struck down the president's ability to borrow money for the Civil War, they then reversed themselves in a year and uphold it. And the dissenters go ballistic, and Chief Justice Chase says this is lawlessness, it's just pure politics, it's kind of Dobbs redux. During World War II, Robert Jackson goes over to Nuremberg. He's the Nazi prosecutor, and Hugo Black is sniping at him from the court and accusing him of being political, and Jackson says Black is evil, and they are absolutely at each other's throats. And then Tiffany's right to mention Justice Scalia, because it's clear that Justice Scalia's invective alienated Justice O'Connor and the moderates. And Scalia would said that O'Connor's opinions cannot be taken seriously. O'Connor responded, "Sticks and stones can break my bones." That's probably not true. And then she voted with the liberals and moderates much more consistently when Scalia was really pushing her. And think about some of Scalia's rhetoric. In the Obergefell case, he said, "This opinion is so bad, it makes me want to put my head in a bag and vomit," he said at some point. He accused the dissenters of mistaking a Kulturkampf for a fit of spite, which is terrifying until you look it up, a culture war. And he was very unbounded in his
So
what's unusual, though, is not the rhetoric, it's the substance of the fact that Justice Jackson at least honestly believes, because she's told us very clearly in her opinions, that she thinks that the president has become a king, the founders' worst fears have been recognized, and this is a zone of lawlessness. But then I would say that Justice Kagan doesn't agree. She's not joining these.
Well, let me just say before we move on, there is something else that should be said about Justice Jackson, which I did not know until I saw it last week. You know, this is her 2nd year, and she actually, apparently in oral arguments, and you would know this because you appeared before her, actually speaks more at oral arguments than most of the other judges. She's authored more dissenting opinions that are of a fiery tone. I couldn't believe it. I read that Roberts didn't even write a dissenting opinion until he was in his 10th year, and Justice Jackson is like, she really hit the ground running. And Neal, do you have anything?
Yeah, so Justice Jackson is by far the most vocal person on the court. She had 79,000 words at oral argument last term. The next highest justice was 53,000. I think the fewest, Justice Thomas, at something like
young people today.
Yeah, so she has a very different approach to the bench than other people. I would say the Chief Justice and Justice Kagan have a similar, not necessarily a similar jurisprudential view, but a similar view of the role of the justice, which is try and build consensus, don't write separate opinions. Justice Kagan's written almost no separate opinions, as has the Chief. Don't talk a lot at argument, ask a few pointed questions. Justice Jackson is doing something very different. And her questions are marvelous. I mean, you know, like I spent years I've been involved in every affirmative action case for 25 years. But what she said in the SFFA versus Harvard argument, you know, and I won't take time to do it here, but was just such a brilliant line of questioning. So she does bring this interesting perspective. There's one other thing I just want to say about this whole question about Justice Barrett and Justice Jackson and what happened last week. I do think there's a gendered component to this in the media, because as Jeff says, like, you know, there have been justices who've used far, far harsher rhetoric in other cases, and it hasn't gotten the same attention as this has. And so, you know, my strong hunch is those 2 justices get along just fine. They're in it for the long haul for 30 or 40 years, and they know that.
All right, let's start.
And you know, when I think Blackmun's papers came out, it became clear that Scalia lost a lot of majorities because he was so snarky.
Well, what Jeff said is that he lost O'Connor all the time.
Yeah, but
Just the same thing.
Yeah, that's true. That's true. But there are a lot of major cases in which he initially had the majority opinion,
and he lost it.
and he was so snarky, and he lost it.
All right.
So, and one other thing, and Justice Jackson is in the line of people like Justice Rehnquist originally, Justice Thomas, where you're kind of at the margin of the court and you're really pushing for the long game.
Okay. All right, let's start. Now we went through the shadow docket. Everybody following? So emergency appeals. Now let's get to the actual cases, and we're going to try to get through them all. Now here's the first case is the birthright citizenship, which is sort of a misnomer because they weren't really deciding birthright citizenship. They were deciding the very thing that Neal started us out on, which is the idea of injunctive relief that pauses the president's executive orders while the case rolls its way through the system. And so therefore, the president is looking to implement the deportations, the firing of people, the elimination of transgender people serving in the military, and a federal district judge stops the proceeding, and Donald Trump goes nuts. He's going, you can't stop me. Not one single judge can stop me. And so that was the debate, right? That he's saying, I'm the president, I received a mandate, I have all these things I want to do, and a single federal judge can't put a stop nationwide. It's one thing if you want to stop something but the parties before me, but not nationwide. So the birthright citizenship case started out as an emergency appeal, and then I don't even know how that happened, and all of a sudden it became an actual case that got argued very quickly, right? It got argued very quickly and got decided at the last case of the year. And in the end, we now know that the 6-3 majority said, yeah, federal district judges can't put a pause, what's called universal injunction, on the whole nation. They can only affect the parties before them. Neal?
Yeah, so just so everyone should know, this was one of my nonprofits cases, our Georgetown nonprofit, the Institute for Constitutional Accountability and Protection, so take what I say with a grain of salt. But we went into court and basically said Trump is trying to eliminate birthright citizenship, this guarantee that everyone has thought since the Civil War that if you're born in this country to parents who are here, whether you're on a visa or you're here on an undocumented basis, you're a United States citizen. That's exactly what we fought the Civil War over. That's what Representative Bingham says when he writes the 14th Amendment, those lines at the beginning. So we went into court and said that. We won right away. The court then did, as Thane says, issue this nationwide injunction. So we filed our case in Maryland, but it now governed the entire country. Anywhere in which Trump wanted to try and take away birthright citizenship, we had a court order that said you couldn't do that. The Solicitor General then did that emergency race that I described to you earlier up to the Supreme Court. The Supreme Court didn't want to hear the merits. They just wanted to hear, as Thane says, this question of a nationwide injunction. And as Tiffany tells us, that in an opinion written by Justice Barrett for 6 justices, the court said you can't have this kind of nationwide injunction for at least private plaintiffs. Justice Jackson writes that dissent, saying it's the end of the rule of law. I think, even though this is one of the cases I care most about, I don't think that this is, I think that was going a bit too far. The court was pretty careful to say there are 3 different paths to getting broad relief. One, you can file a class action, which is an idea that says we're filing on behalf of many people, not just on the one person, the plaintiff, and you can get relief there. Second, the court says that state attorneys general can sue the president and possibly get nationwide relief. They've left that question open. And in this climate, there's always some state attorney general who wants to take on a president. We saw in the last administration, and we'll see in this one. And then third, and most importantly, the court left open the possibility that challenges under the Administrative Procedure Act can result in a nationwide injunction because that precedent goes back to the 1950s. And many of these executive decisions are implemented by agencies, and you can sue the agencies over them. So I think the time will tell exactly how extreme this decision is. I'm certainly no fan of it, but I'm also no fan of the rhetoric right now which says end of the rule of law. And I do think there was a kind of bizarre coalition between the hard left and fueled by Justice Jackson's decision and President Trump, who immediately declares victory and says, this is, I can now do anything I want with respect to birthright.
You're right. What he actually said, which could come back, he may not win this one. He actually literally said he gave an illegal opinion. I don't know how he did this. He said, the 14th Amendment only applies to the children of slaves. He explained this. He just told everyone, I won, I won. Now, the case wasn't even about birthright. It was just, as we said, it was about the injunctions. But I don't think he knew that. So he just showed up and declared victory, and he said the 14th Amendment applies only to slaves. I actually think he's going to lose this one, and that'll be a great soundbite.
There are a lot of white people who would find that surprising.
Well, also, just quickly, there is a case from, 1898, of a Chinese American whose parents were not American citizens, who was born here. So in 1898, we said a Chinese American is, in fact, a citizen under the 14th Amendment, and he was not black, and he was not had anything to do with the Civil War or slavery. So let's just move on now to
maybe just one historical point about this. Maybe one historical point about this very crucial question. First, it's really significant that Neal tells us that time will tell. We don't know what the practical effects of the decision will be. But it is true that this question of whether or not the president has to obey a decision beyond the parties to the case goes back to Hamilton and Jefferson. This new book that's coming out in October, The Pursuit of Liberty, is about how the battle between Hamilton and Jefferson defined all of American history. And when it came to the Supreme Court, Jefferson insisted that he only had to apply Supreme Court decisions to the party in the case, but not more broadly, and that as president, he could make up his own decision about how to interpret the Constitution. John Marshall is so afraid that Jefferson is going to defy him that in Marbury versus Madison, he does these somersaults to avoid ordering Jefferson to do anything, because he says, I'm not fond of butting my head against a wall in sport. And that position, it's called departmentalism, is embraced by Abraham Lincoln, who says he's not going to apply the Dred Scott decision across the country, but only to the parties in the case. It's embraced by Franklin Roosevelt and by Ronald Reagan, by all of the presidents that are viewed as constitutionally transformative in American history. So it's not unprecedented by any means for a president to say, I don't have to apply Supreme Court decisions more broadly than they actually appear. But that leads to the broader question, which maybe we can tee up next. The court is clearly afraid of being defied by President Trump. And President Trump had threatened to defy lower court decisions, and of course there have been attacks on lower court judges and calling for their impeachment. There was that remarkable moment when all 9 justices converged to say that President Trump had to facilitate the return of Mr. Garcia, a carefully chosen word, because they clearly were afraid that the administration was going to defy the lower courts. My sense is that Chief Justice Roberts is very eager not to be defied. His hero is Chief Justice Marshall. Well, he's an institutionalist. Right? He's an institutionalist. His hero is Chief Justice Marshall. He has Marshall hanging in his chambers. He's embraced Marshall as his model. And like Marshall, he's not fond of butting his head up against a wall in sport, and he's trying to pick his battles to avoid ordering the president to do something that he won't do. Now, the question is whether he should be viewed as Chief Justice Marshall, a canny tactician who's kind of keeping the court's powder dry, or as Steve Loddock said in our review last night, as Neville Chamberlain. And I'll leave it up to my colleagues to decide.
So before we leave, there's one thing that you just reminded me of, and it's actually, there's a case tomorrow in New Hampshire. By lifting the nationwide injunctions, it does create, I think, a headache for the Supreme Court, because they, seems to me, now have an obligation to fast track. These things got to move faster. So I think Sotomayor said in her opinion, she said, all right, well, let's just roll with these class actions. Let's go, let's go, let's go, because if you can't enjoin it, remember the disparate result. You're born in one state and your parents are not citizens, you're not a citizen. You're born in another state that interprets it differently, and all of a sudden you're a citizen. So we've got to fix this. So the Supreme Court's going to have to get through birthright citizenship faster. And guess what? Tomorrow in New Hampshire at 3 p.m., they're trying to certify a class to start this process. All right, let's move on to...
One quick thought, just really
oh,
quick.
God.
Sorry.
So you guys brought the sleeping bag, right? You've got a note with that. Guys, you know we're not even close. All right.
One of the things that's so interesting about these nationwide injunctions is the way that they are employed by both sides of the political divide. If you've noticed over the years, you see that during a Democratic administration, it's very common for Republican attorneys general to run to the Fifth Circuit, whereas during a Republican administration, it's very common for Democratic attorneys general to run to the Ninth Circuit, or perhaps some of the others. And one of the things that's been frustrating for me, as transparently a liberal, is watching some of these decisions come out of a nowhere courthouse in the middle of Texas, and they enjoin action over the entire country. But if I were conservative, I would be deeply frustrated by seeing a decision come out of Seattle that does the exact same thing. And so, it's kind of hard to really wrap your arms around this decision in terms, if you're thinking about it politically, to sort of try to sort through how to feel about this, because Barrett's opinion is not absurd. It's not. But when you're thinking,
But it's also the case in which,
sorry,
You kill
it's
these people.
interesting.
We'll be
Seriously,
back.
did I remember I said friends? Forget it.
But during the Biden administration, all the liberals were like, you got to stop. The conservative judges in Texas were issuing nationwide injunctions, and it was really grinding the Biden administration to a halt. The question is, why now? Right? In other words, during the Biden administration, the Supreme Court didn't kill nationwide injunctions, and it does it now, and it also does it in a case in which the law is pretty clear, right? So, a lot in the Biden administration, there were arguments on both sides, and the Supreme Court didn't do anything. This is a case in which the text, the legislative history of the amendment, and the Supreme Court all very clearly say birthright citizenship means if you're born in the U.S., you're a citizen, period.
All right, one last thing. Remember, it was, in fact, Justice Kagan during her nomination hearings in which she expressed a problem with nationwide. So that's why when Tiffany
Every
said,
Solicitor General has.
Right, exactly, right. So I'm saying it's not like when you said, it's not like Barrett is insane, like everyone has had this view. All right, the Tennessee case dealing with gender-affirming care. This is the case in which Tennessee passed a statute that said, you want to transition to a different gender. If you're an adult, good luck to you. You want a surgery, it's up to you. You're an adult. If you're a kid, let's not even deal with surgery. Hormone blockers, puberty blockers, hormonal therapy. We don't trust it. We don't think it's safe. We don't want any Tennessee kid doing this. By the way, those same drugs can be used by other kids in Tennessee for other reasons, but not to change gender. Right? So apparently some of those drugs work nicely for anxiety, right? So you could be taking for anxiety, but they'd have to check with the kid. You're not doing this because you want to change your gender. So the Supreme Court ended up ruling 6-3, right, that in favor of Tennessee's decision, saying essentially that the state had a compelling state interest to protect its kids, I guess, and the other argument is, but the 14th Amendment is being violated because there's an Equal Protection Clause argument here. And that seems to me a very strong thing. And the court said, well, forget it. We're really worried about the kids. In fact, I would say two things about this term. One was it involved a lot of kids. Some of the cases all involved kids. Here's kids. And it also was a very good year for social and religious conservatives. All right, anyway, what do you guys have to say? Jeff, you were interested in this.
Well, it's so interesting constitutionally and also in terms of the culture wars. So constitutionally, the court rejects the centerpiece of Justice Ruth Bader Ginsburg's vision of gender equality. That was most interesting to me. Justice Ginsburg had argued that laws that reinforce traditional stereotypes are constitutionally suspect. And that was the basis for her criticism of Roe v. Wade. She said that it shouldn't have been decided on privacy grounds, but because laws that prohibit women from deciding to do what they want with their bodies and to make decisions about their careers reinforces gender stereotypes, laws on abortion are unconstitutional. The court in Dobbs rejected that claim on the ground by citing a case called the Geduldig case that said that pregnancy discrimination doesn't discriminate between men and women, but between pregnant women and non-pregnant persons. And that technicality was the core of the Dobbs majority's response to the dissent, saying it can't be gender discrimination because it's not discrimination on the basis of sex. It was the same Geduldig case that gets resurrected in the middle of the Skrmetti case, and Chief Justice Roberts says that
Skrmetti case is this case.
This case involving
gender
whether you
affirming.
can have access to these drugs. Chief Justice Roberts says this only just doesn't discriminate on the basis of sex, but on the basis of purpose and age. You can't have the drugs if you're young, if you're a teenager, and you also can't have them for the purpose of transition, but you can have them for other purposes, like anxiety or stopping hirsuteness in women as long as they're not trying to transition. So for that reason, the chief said, we're not discriminating between trans people, but between people who want to use the drug for one purpose or another. And in the process, the dissenters said, but Justice Ginsburg rejects this idea. You don't have to cover everyone in the class, but if the main purpose is to discriminate against individuals who want the drugs or who want pregnancy, then it is sex discrimination. So the big picture for me was that the court totally rejected Justice Ginsburg's anti-stereotyping jurisprudence, making it impossible to resurrect that before this court as an argument against abortion restrictions. It also rejected the idea that trans people are a suspect class who, like women or racial minorities, deserve special constitutional scrutiny. And Justice Barrett, in her concurring opinion, was very methodical in saying, look, we're not going to recognize new suspect classes unless three things are present. It's an immutable characteristic, it's not related to ability to contribute to society, and there's a history of discrimination. And here she said, here transgender status or one's gender identity by definition is not immutable because people are trying to change it. And it's not, and then most importantly, she said there's no history of de jure discrimination, in other words, of recognized discrimination written into the law. Justice Sotomayor responds, well, transgender status is a new thing. There can't be this formal history. That's too high a bar. But broadly, the conservatives, and Justice Alito and the others joined this, said we're not going to add new suspect classes. The list is closed, and without a really clear history of de jure discrimination, you can't get heightened scrutiny. So that's very important doctrinally, because it suggests that there aren't going to be new groups added to the list. But then there's this whole question of the empirical evidence, and Justice Thomas had a long concurrence saying, this evidence is very disputed. Europe is not allowing these treatments for young kids as young as 11 and 12, and it's just too uncertain for courts to weigh in one way or the other. The states are entitled to make up their own minds. And even Justice Kagan, who thought that it should have been examined more closely by the lower courts, didn't say automatically that the statutes would fall, but just that you had to evaluate their actual health benefits or whether they were based by animus. It's a lot, I know, but it was a really interesting case at the center of the culture war, and the court basically said, we're not going to be in the business of creating.
Okay, let's move on to two other cases. Tiffany, maybe you can help us out with that. Just to give you a summation of that, remember this deals with what Jeff was talking about is gender affirming care, but it does raise the question, well, what about sex and neutral bathrooms, access to bathrooms? What about transgender sports in schools, in public schools? That's actually coming up next year. So you can look at this as an initial precedent on how the court feels about transgender care, because there are other things, and also they ruled in favor of denying transgender people serving in the military under the emergency order. So we're getting an inkling of where this is going. Two cases that dealt with schools, Tiffany. One is out of Oklahoma, which oddly was 4-4 because Justice Barrett recused herself, just like one of you said something about Justice Jackson recusing himself. During that year, it was also 4-4. This is a case that deals with public charter schools, one in particular in Oklahoma, that wanted to be a public charter school that taught religion, Christianity. And of course, that violates the spirit of the separation between church and state, technically violates the First Amendment because of that split. The state is not supposed to be funding religious education. Public charter schools are charter schools, they're public schools. And the Supreme Court ultimately, the Supreme Court of Oklahoma rejected the attempt to fund those schools with public money because it would be religious. I don't know whether you think that if Justice Barrett had been there, she would have ruled in favor of the school to say, now I guess there's one quick precedent, which is the court recently, and if you've been here before, there was a court case recently that said if the state is funding private schools, it can't deprive religious private schools. So that's like a hook to hang this on, right? If you're going to give it to one, give it to the other. Years ago, we talked about if you're going to pave the playgrounds of schools, of elementary schools around the state, you can't not pave the ones, even as with public funds. So how do we understand this case, given the fact that it was 4-4?
I mean, I think that I'm not sure how to understand it, to be completely honest with you. From what I could tell, what Chief Justice Roberts was suggesting in oral argument was he was sympathetic to the decision from the Oklahoma Supreme Court. And so perhaps that's why it split 4-4. He may have voted with the liberals. But honestly, I think that it's going to come back. It's not going to be another lawyer from Notre Dame who would put Barrett in the position of needing to recuse herself. And I really don't know how she's going to come out. I mean, religious organizations, religious practitioners do very well before this court. They simply do.
On religious liberty grounds.
On religious liberty grounds. But this is such a blatant thing. I mean, the case that you brought up, it was a case from Maine from a couple of years ago, where Maine is a very rural state, as you all likely know. And so it can be difficult for kids to get a public school education. And so as a consequence, the state was funding the ability of parents to send their kids to private schools as long as they were non-sectarian. And the court has developed this jurisprudence in religious freedom cases over the course of the past couple of years, a very robust jurisprudence of neutrality. You have to treat religion and non-religion the same. And so that's why the court in that decision said that you cannot exclude the sectarian schools from receiving these funds as well, because that discriminates against them. I think the distinction between that case and the Oklahoma charter school cases, there's no discrimination here. There's just a decision to fund religious education if they can get away with it. And so I am hopeful that when the issue eventually comes back to the Supreme Court, that we will get at least a 5-4 decision saying no. The court has very much allowed the free exercise clause to overtake the establishment clause over the course of the past couple of years, and I am hopeful that that will not continue.
Just a quick reminder, right? The freedom of religion has two pieces to it in the First Amendment. The first is the right to practice your religion, but it also tells the government that you can't establish, you can't favor, you can't fund. We, the government, aren't unlike France. We're not in the religion, actually not unlike other countries. We don't fund religion, and so that's where the separation between. Now, what about the Maryland case? That's, I think, fascinating. That's the case dealing with parents who brought a lawsuit because they wanted to opt their children out, to withdraw them on days. These are little kids, in which the teacher was going to teach a storybook that had gay and lesbian characters. And so in this area, the parents are saying, whoa, whoa, this is conflicting with my religious principles. I have a First Amendment right here. I'm paying taxes, and you're violating my religious liberty. There is a long history of cases that says, yes, but public education is important, and that oftentimes it might even trump a constitutional right. What's a really good example of that? Rambunctious kids who get up in class and make speeches, right? You tell the kid to sit down, the parents can't show up the next day and say, you violated my son's First Amendment rights. You're allowed to, the school can run itself. And I think Justice Kagan was saying, how do you expect schools to be in business if kids are running out all the time because their parents don't want them to hear something?
Yeah, this is the Mahmoud case, and it's very interesting as well. It's a parents' rights. It's a religious freedom case and a parents' rights case. They're sort of filtered through each other, where the Supreme Court said that if you substantially impair the right of a parent to direct the religious upbringing of their child, that's going to violate the free exercise rights of the parents. And in this case, the court because that was the articulation of the right, the court ends up applying a very stringent test to evaluate it, and the state was not able to sustain its burden under this very stringent test, and so that's why the state ended up losing, the parents end up winning, and you can, excuse your kids. But that, from a doctrinal perspective, there are a lot of sort of nuances there that I won't get into because it'll take too much time and Thane will get mad.
Yeah,
but
true.
what's so interesting to me about that case is what it says about the success of anti-LGBT claims that come before the Supreme Court. What if they were not objecting to the storybooks that dealt with gay couples getting married or having a transgender child, and instead it was a storybook about an interracial couple getting married? The same kinds of questions arose several years ago in the 303 Creative case, where Justice Jackson was making the same point. That was for those of you who pay attention, you all pay attention to stuff. Really quickly, that was the
Colorado
website design.
The website design. Remember, when you were here back in other years, there was the Colorado cake maker and the Colorado web design. This is the web designer.
Right.
Colorado.
And so in any event, what's the Supreme Court going to say if someone says that they have very deep, sincere religious objections to instruction that undermines what they're teaching their kids about race, or undermines what they're teaching their kids about gender relations? Is this court going to apply the same kind of freedom or grant the same kind of freedom to these religious parents as they do to the religious parents who raise objections regarding LGBTQ status? I don't know what's going to happen, but we'll
I want to
see.
get to ghost guns. Before that, I just want to ask, how come no one's talking about Inherit the Wind? I mean, isn't this Inherit the Wind, the Scopes monkey trial? Right? I mean, didn't Spencer Tracy already do that? I thought he did that. I saw the movie. It's excellent, by the way. And I learned from movies that the school can teach creation. I mean, they can teach science, evolution. They can teach about Darwin. And the town doesn't get to decide that their understanding of the Old Testament governs the science in the classroom. All right, Bill, I know you want to talk about ghost guns. Ghost guns are interesting because it's got a great name, because it's a kit. There's statute that the government can regulate guns. The question is, what is a gun? Well, what if the gun shows up a la carte in a kit, various pieces, every single piece, and you, like a model airplane person, puts one together, and you put a bullet in, it works. And that's a ghost gun. And yes, let me tell you something about those ghost guns. They have no serial numbers. There are no background checks to get anything like that. You could just put it together. And so the question became, well, these guns are being used in violent crimes. And so should they be treated separate from other firearms because they're actually split up into pieces rather than coming in whole?
So, first of all, this is, I think, my favorite decision of the past term because it's one I agree with. And so, just in terms of Supreme Court doctrine, so when I was in law school, when you were trying to understand a statute, you looked at the legislative history. What did people say they meant by it? So this statute was passed right after Bobby Kennedy was shot. And it said, no weapons unless you have serial numbers and do background checks. So if you looked at the legislative history, I think it's pretty clear that when you've got a new technology, I mean, they didn't have ghost guns in 1968. It's since then. But if you'd asked people in 1968 and said, look, there's going to be a new technology where you can put together guns in pieces, is that a weapon? They would have said yes, right? But that's not the way, really, because of Scalia, we look at statutory construction. We don't look at what they said they meant. We look at what the words are, okay? So the word is weapon, right? And is a gun kit, is a gun that you have to put together a weapon. And the Supreme Court, I think this is fascinating because Thomas in dissent says, a gun's a gun. If you have to put it together, it's not yet a gun. That's the way we understand the word gun. So it's not a weapon. Gorsuch, who's the biggest textualist on the court, this is actually a Georgetown brief that he follows, says, by linguists at Georgetown, say, we have a concept of artifact nouns, and that becomes decisive in the case. What's an artifact noun? So there's some things that are just what they are, an egg or a dog. Artifact nouns are things that you put together. And in linguistics, that can either be, it's not that word until it's done, or the pieces count as the finished thing. So for example, and this is, Gorsuch uses this in his opinion, the majority opinion. I go to IKEA and I want to buy a table, right? And I come home and my wife Allison is here and she says to me, what did you buy at IKEA? I will not say I bought table parts. I will say I bought a table, right? And so that's actually, that's the
Does Gorsuch use that actually?
He uses that, not, he doesn't mention Allison.
Yeah.
But it was, it was teed up at oral argument because Justice Alito asks the brilliant Solicitor General Elizabeth Perloger. He says to her, if I have some eggs on the counter and some onions and some peppers and some cheese, do I have an omelet? And she says, no, but that's because you can use those for other things. Imagine that you had a meal kit that you'd ordered, where every one of those ingredients was all directed towards one thing, then you do actually have that underlying product.
Right, because the pieces themselves have no other purpose other than as one thing.
So again, it's interesting because the studies there's sometimes where the parts are not, for most people, used as the whole. So bicycle parts, you don't think of as a bicycle. On the other hand, if I'm writing a novel and I say, Neal, I'd like you to read my novel, and I've only got 3 chapters, that's still, you would say he's reading my novel, even though it's not done. So the linguists say, most people say weapon parts are a weapon. Like most people would say table parts are a table. And that becomes the key to the decision, which is remarkable. The idea that the concept of artifact nouns is deciding a Supreme Court case is stunning.
Cool.
And cool.
And it was cool that we got Allison in there. We always get Allison in there. We always, either I do it or he does it. Neal, TikTok. There was a case this year, the TikTok case. You may remember Congress passed a statute that said, everyone's using TikTok. It's not owned by China, but it's almost owned by China. They have an incredible amount of control. There are enemies, number one. Number two, they collect data. It's not a good idea to have TikTok be owned by China. Sell yourself or leave, right? Now, Donald Trump stopped and, well, let's not get so carried away. I like TikTok. Let's try to find another buyer. But there was a deadline, right? And the challenge was to say, hey, you're supposed to go out of business. TikTok said, well, don't we have a First Amendment right? And importantly, not just TikTok, but the people that use TikTok said, hey, don't we have, I sell my stuff through TikTok. What are you doing? You can't shut this down in the modern era. This is how I live my life. So it became a First Amendment question on a company with sort of creepy connections to a communist regime, but yet was able to seek the protection of the First Amendment. And then I think you've argued these cases before, it does seem in post 9/11, because you handled Hamden, if you say the word national security in our country in front of a federal court, especially in the Supreme Court, you kind of win, right? It does seem you mostly win, and in this case, the court said, hey, this is a question of national security, and it's more important than the First Amendment rights of someone dancing with their cat.
Yeah, you certainly, I do think that you win often in national security cases, but not always, and Hamdan is a perfect example in which the court struck down the Guantanamo tribunals, even though the president said it was necessary for national security. So in the TikTok case, Congress passes this law because of this Chinese connection, Chinese CCP connection with TikTok, and says on January 19th, you've got to either divest control, China, or cease operations. And of course, nothing happens. And so instead they file a lawsuit. And on January 17th, 2 days before the law was to go into effect, you have the Supreme Court issuing this decision that basically says that TikTok, they reject this idea that TikTok has a First Amendment challenge. It says the law is, because of national security, constitutional and can go into effect. Donald Trump, as president-elect, filed a brief in that case, and the brief literally said Donald Trump is the best negotiator ever, and as a result, nobody can negotiate like him, and as a result, the court should just wait until January 20th. The court doesn't wait. They issue its decision saying that the TikTok ban should go into effect. Now, Congress, when they wrote the law, said that, that there was a one-time exception that the president could make. And if he made certain certified findings for one time for 90 days, the suspension of TikTok could be put on hold. So what does President Trump do on January 20th? He suspends it for 90 days, no certification, and then he suspends it for another 90 days and another 90 days because he has difficulty reading what a one-time exception means. And that's where we are right now. And this is a very dangerous constitutional thing because, and we now know this from Freedom of Information requests that came out last week. Basically, the law didn't just prohibit TikTok from operating. It prohibited any service provider from aiding TikTok. So every time Apple installs the application on your phone, that violates the TikTok statute, or Google on their phone system and the like. So billions and billions of dollars in damages are potentially there. What did the Trump administration do? They wrote some secret letters to these different tech companies and said, don't worry, what you're doing is not illegal. Now, that is not something I've seen happen to my knowledge, in our lifetimes. We've certainly had examples of the executive branch doing stuff that's outside the law, but here what you have is an executive licensing illegality by third parties and saying, don't worry, I'm not going to enforce it against you. And if you think back to like the English Declaration of Rights of 1689, one of the complaints about the king is that he had the pretended power to suspend the laws and the execution of the laws. There's a reason why Article 2 of our Constitution says the president shall, quote, take care that the law be faithfully executed. It's a direct result of that 1689 history. And what you have now is a president saying in secret to his friends, don't worry, I'm not going to enforce the law against you. I can't think of something that could be more dangerous.
All right. Stay tuned. That case is not going anywhere. And it's, as Neal pointed out, it's ongoing. Let's talk about the Texas age verification case. This is another kids case. Texas passes a law that says if you're a porn site, or you have pornographic material, or for that matter, if you're the Game of Thrones, for God's sakes, because there are a lot of naked people there, you just can't go on the website to watch it. You have to show us that you are of the appropriate age to be able to watch this kind of sensitive material. We Texans take this very seriously. We don't want our kids watching porn. We want them doing other stuff, like football, for sure, in Texas. And so the idea is, okay, well, what's wrong with that? Well, what's wrong with that is that there are a lot of people like porn, Bill, right? Look, Allison is here, and she knows it is an issue.
You're upset that I've been interrupting you.
He'll whisper in my ear very soon. People who like porn are saying, I don't like people knowing I like porn. And so I don't want to sign my name online and tell you what I'm watching. And I have a First Amendment right. Remember, First Amendment works in both directions. You have the right to speak, but you have the right for the government not to force you to speak. And this is an example, right, of the government forcing me to speak by making me provide information that I don't want to. And so therefore, you violated my First Amendment rights. And the Supreme Court ruled, not unlike Tennessee in their protection of kids, theoretically. They're saying we're protecting kids again. Here in Texas, and we're saying we're gonna override whatever First Amendment protections you think you have because we have a compelling state interest to protect the kids. What do we think about this case? Jeff?
it's striking that just a few years ago in the ACLU v. Reno case, the court came out basically the other way. And at the dawn of the internet age, the court said that any effort to protect kids from porn has to meet the highest level of constitutional scrutiny, strict scrutiny. In this case, by contrast, they subjected the law only to intermediate scrutiny by invoking a category from the 1960s called illegal for minors, which is a much broader character of speech than can be banned for adults. Now, again, in practice, it's not totally clear that the difference makes a huge practical effect. Justice Kagan, who wanted to apply strict scrutiny, said maybe this law can pass strict scrutiny. It does make sense to have age verification for kids, and if this is the least restrictive way of doing it, then it's possible that the law could succeed. And she wanted to send it back to the lower court for that reason. But it's striking that this is a court that generally is in favor of the First Amendment on steroids. It rarely rejects First Amendment claims. There's a bipartisan consensus around First Amendment issues. Many observers think that if the court is likely to rule against the Trump administration next year or in future cases, it may be in cases involving the law firms, which have strong First Amendment interests involved, and the justices may all agree that you can't penalize law firms because of their speech or representation. But this was different, maybe because it's porn. Some of the opinions suggested it's a real problem online. Conservative commentators like David French had a really thoughtful piece saying it is a really big problem online and it's important to...
Well, you know, I'm sorry, I just remembered, you just reminded me. I think Justice Barrett said, either in the oral argument or in a concurring opinion, she said, I have kids, and if you think I can police their phones, you're kidding. Like, you can't put me in charge of this. I'm Associate Supreme Court Justice, and I can't control this. This is a problem.
Right, and that's a change from the Reno case. So when the Reno case, was decided by the court, they thought that parental filters worked, right? So, that's an example in which we now know, and my son Liam is here, they don't, right? So the technology, I think, is also, the change in technology, I think, is also part of the reason why the court moved from the Reno case to now.
Jeff, when you said, I love the line, First Amendment on steroids, did you mean First Amendment speech or First Amendment religious liberty? Because, if you've been following us over the last few years, there's been a whole swoon of these cases. Remember the football coach that wanted to say a prayer at public school on the 50-yard line after the game with other players? Remember the Catholic adoption agency that said, well, we really don't want to handle an adoption with a same-sex marriage couple. So there have been a number of these religious liberty cases. Historically, America we are much more progressive and expansive in our First Amendment protections than would, say, Western European nations. But I'm just curious, did you mean speech or both speech and religious liberty?
I meant both. The religious liberty protections we've been talking about, they're familiar, and there's no doubt that this case is strongly favorable to religious liberty. It's significant, as Tiffany was suggesting, that some of those religious liberty cases are unanimous, including all 9 justices agree that you can't not give a tax exemption to a religion because it proselytizes. But in addition, the court is really in favor of political speech and might well rule in favor of law firms on the grounds that they have a political and constitutional right to represent unpopular dependents and to challenge the administration. And what's striking is the First Amendment generally is not polarized, except in campaign finance, where Justice Kagan accused the majority of, I think she called it First Amendment Lochnerism, referring to the Lochner case, which struck down economic regulations in the progressive era. But with that exception of campaign finance, the justices generally really protect unpopular speech, including in the Reno case porn. This is a bit of a retreat from that, but I think Bill is right that it has more to do with changes in the technology than backing away from strong protections for free speech.
All right, a few more cases, and we'll take some questions from the audience and say goodnight. There's a few more that I just want to make sure we get through. One is the case where Mexico brought a lawsuit against the American manufacturers of specifically machine guns. And they're saying, we have a drug cartel problem, but we don't really make the guns. You make the guns. And you have a problem with us because of our drug cartels. Aren't we aligned in our interest here? Let's put a stop to the companies that are creating these guns that should not be made at all other than for military purposes. There is a broad immunity given to gun manufacturers in the United States because otherwise every single mass shooting would have put them out of business by now. And so the question is, does that immunity also apply to a foreign country who comes to us and saying, we want to help you, help us help you by just stop making these guns and stop protecting these gun makers? I guess, is anyone here surprised that it was 9-0 in favor, right? It was 9-0 in favor of upholding the law, right? It seems like a no-brainer. All right, good. How about e-cigarettes, flavored cigarettes? Another kid's case, right? Yet another kid's case. The idea here is that the Bureau of Tobacco and Alcohol said, look, we want to regulate these, we want to restrict the use of this, and it's harmful to kids. Another 9-0 case. Nobody's surprised with that.
Yeah, I mean, that was one that just made so much sense.
That one, right.
Yeah, I was not surprised by that outcome.
Reverse discrimination case. Here's one that I found interesting. The reverse discrimination case. We think of Title VII and improperly firing someone or treating them poorly, harassment, based on their sex or ethnicity or race. You have a woman who's a white woman who is passed over for 2 different promotions by gay men and women, or I think 2 gay men, and her supervisor is gay, and she's saying, don't I also get protection under the Civil Rights Act simply because it's just I'm a white woman?
Yeah, that was an interesting one because there was a rule that essentially said that, well, in order to succeed on these employment discrimination cases, you had to initially be able to establish that there was intentional discrimination. And in these cases, what the courts were saying, what the lower courts were saying was, if you are going to allege that you are experiencing discrimination as a member of a majority group, then you're going to have to show a little bit more than what you would typically have to show in order to proceed. And of course, in this case, she is a member of a majority group, not because she's white, but because she's straight. And so, the court in this case said, no, that's not consistent with what the text of Title VII actually says. If you are experiencing intentional discrimination under, as a member of a protected class, then you are going to be able to at least attempt to push forward and prove your claim. And in this case, she was able, the Supreme Court said, yes, we're going to let you proceed with this litigation because that additional burden placed on you is just not consistent with what Title VII actually says. And I mean, and it makes complete sense, right? Because why would you say to someone who is explicitly being discriminated against because they are straight, because they are white, because they are a man? I mean, you can point to some really interesting theory that shows up all over the law reviews having to do with who's being subordinated and who's not being subordinated in order to justify making these kinds of determinations and drawing these kinds of distinctions. But given the way that the Supreme Court operates now in the context of anti-discrimination law, whether you're talking about statutes or whether you're talking about the Constitution, there is this desire to try to equalize the playing field and kind of say fair is fair. And if you are being mistreated because of this protected class that you are in, because you're a member of a protected class in some way or another, or on the basis of a protected class status that you possess, then you ought to be able to proceed with a lawsuit just like anybody else.
Given the fact that Donald Trump is so upset with DEI and so many of the executive orders even dealt with DEI, and I know you've had to deal with this at Georgetown Law School, I wonder what, I'm sure he hasn't given this much thought, but this is a case in which diversity was not, this was not protected. The person was white. It was able to actually come before the Supreme Court And you would think that they said, no, it does, you have privilege. You're white. On the ranking system, you don't have any, you get no benefit here. And in fact, she actually wins this case.
But it's interesting. I mean, I think there were a court of appeals that had said that you should have a higher standard.
Because she was a white person.
Yeah, because she was a majority person, right? So, I think Jeff raised an interesting point about kind of the strategy of members of the court. And so you focused on dealing with Trump, but I wonder whether in a different setting, the left of the court would say, maybe we'll win on this. And so they would have been more aggressive. But it's quite clear that in this, the way the court is going, they weren't going to win. So it was better to kind of sign on and say, everybody's equal. So again, we'll never know. But given the fact that there were courts of appeals that came out the other way, I think it's at least a possibility.
All right, I'm going to roll through a few cases so you can keep, if you're scoring at home, these are cases that are coming up next term, right? Give you a sense of here, what's coming up, and then here's what we'll be back next year, hot dogs, fireworks, and law of the land. So here's what we'll be discussing. This is one case, two cases that emanate, one out of Idaho, one out of West Virginia. Transgender sports participation in female sports in public schools. These states put a ban on allowing transgender students to compete against girls in public schools. There's a campaign finance law case dealing with something called coordinated campaign financing, where if there's a limitation on how much a candidate can spend, well, can he or she override that limitation by taking money from the party? The political party tosses in their own money, and that way you get to spend more money and you don't violate campaign finance reform. Here's one that's interesting. Colorado has banned, Colorado is always in on this stuff. Remember the master cake? Tiffany talked about the graphic designer, the web. This is a ban on psychotherapists who are religious and their job is conversion therapy, to try to talk kids out of changing, becoming homosexual or whatever gender classification they're looking to change, or sexual classification. And the plaintiff is saying, first of all, I'm a religious person. I'm not just the therapist, and I have a right to my religious beliefs, and I have a right to my First Amendment rights, and I have a right to my employment, and I have this business. This is sort of what I do. And so there's another example where sort of anti-discrimination laws come up against the right to privacy or other First Amendment protections. And then the man of our GQ heartthrob is going to argue a case. Here he is. You have him here. He'll be arguing in front of this room. Imagine. There he is. So eloquent. A case challenging Donald Trump's tariff policies. Donald Trump is basically saying, there's some statute, he'll explain it, it's the International Economic Emergency Powers Act, and again, it sounds like national security to me. It sounds like a national security argument. I can do whatever I want, and the people that are challenging this, who I think you represent, are saying, well, Congress has the power of the purse. They deal with spending and money, and you're not the tax guy. Taxes come out of Congress. So want to give us a preview of your argument, Counselor?
Sure. So I represent a bunch of small businesses, a wine importer and others, that are very deeply affected by these tariffs, which can be as high as 50% and apply to many of the countries around the world. I'm arguing it in the federal circuit, the Court of Appeals, later this month, before the full one. It hasn't been granted by the Supreme Court yet. I think many suspect it will go there, but we don't know that just quite yet. But basically, the law says, in 1974, Congress passed a law, the Trade Act, which says that if the president thinks there's a really serious trade deficit with some other country, then he can extend the tariff schedule by 15% for 150 days. So what does Donald Trump do? He extends it by 50% and indefinitely. Again, that reading thing. So that's our basic argument, which is, look, the Congress has said how you deal with trade deficits is in this way, 15%, 150 days. What he does is he takes a later statute, this International Economic Act from 1977, which he says gives him sweeping emergency powers. Now, no president for 50 years, since that law was passed, has ever thought it allows him the power to provide tariffs of any sort, let alone global tariffs like of this magnitude. And here's where things get interesting. For the last 4 years, the Supreme Court has been striking down Biden initiative after Biden initiative, saying those are major questions, and you don't have the Congress hasn't expressly given the president that power. They did it with respect to greenhouse gases. They did it with respect to student loans. They did it with respect to the eviction moratorium. In all these cases, Biden was saying, look, it's an emergency situation, student loans because of COVID or whatever, eviction moratorium. And the Supreme Court said, if you want those kinds of powers, Congress has to give them to you clearly. So we're just reading that language back to them. That's the preview of the argument.
And
Did I mention he's not only argued more cases than Thurgood Marshall, but he's so young he might actually get the record. What is the record?
Not even close.
Oh.
I mean, Ed Needler just retired from the Solicitor General's office at 155 cases.
All right, just file stuff and hire him. Just file stuff against your neighbor, like I told. All right, let's take some questions from the audience. This one is a loaded question. This will tell you what this person thinks. Why is the 14th Amendment disregarded while the Second Amendment is upheld? I just love that question. It's pretty simple and set up that way. I don't think you guys agree with this.
Yeah, I don't agree, but I was just in the spirit of previewing next term. I do have a case that that some people think will go up, the Hawaii gun control case. So
Right.
basically, the court has over the last years, they first said that there's an individual right to bear firearms, which reversed a decision from 1939, but they did that some years ago, and then have extended that further and further to include different types of weapons and so on, and where the weapons can be carried. So this case involves the question of, like, can Hawaii and other states ban guns from schools, from parks, from beaches, from subways, from stadiums, and the like? And the Second Amendment folks are saying, nope, you have an unlimited right to carry firearms everywhere. We do think this is a good case to watch because this is a place in which reasonable regulation should be permitted.
But it's also, again, this is a court that says that it's originalist, and yet they're bad in case after case. So, most historians think there is no individual right under the Second Amendment, but the Supreme Court has said that it is, and it goes farther and farther and farther. So we hope that this is a dividing line where they say, no, that's too much. But again, they disregard history, even though they say that's what we should be looking at.
All right, here's a question that we probably got the last few years, but we should keep asking it. Assuming a Democratic Senate and President, can the Supreme Court be expanded to 13? If so, can you pass a law to fix the number of justices at 13? I think we've talked about this in the past. There have been, remember there was Franklin Roosevelt's court packing, and there have been times, I think Jeff was giving us the example in the 19th century with Grant. So what does the Constitution explain this as under Article 3?
So the Constitution gives that power to Congress to set the number of seats. We started with 5. We had 6 for a while. At one point, we had 10. When you have an even number, it's obviously a problem because you can have a tie by an equally divided vote of the court, and then that sets no precedent. So you got all sorts of problems. But constitutionally, Congress could do it. It would require practically 60 votes in the Senate unless they wanted to nuke the filibuster rule, as well as the House. So this is never happening, okay? So it's just a fantasy, but just to indulge the fantasy, I think it would be a really bad idea. So suppose the Democrats do sweep in 28, and they have the power to do this, and they expand to 15, and they put, my niece and nephew who are 9 years old, on the court, whatever, Then the Republicans will win in 32, and they'll put, they'll expand the court to 21 and have their 9-year-olds on. And then, in 36, it'll be 47. And pretty soon you have the Supreme Court of India or Switzerland, each with 100 members, and you lose what's special about the Supreme Court.
I'm going to take one last question, and this goes to sort of the heart of the law of the land that we've been struggling with the last few years. Some people write us, or based on who are here, watching at home, watch it on YouTube later, and say, how come you don't have any more conservative people? Why aren't there more? And we try. Last year we had Jess Brevin, actually, worked at the Wall Street Journal, sat next to Tiffany. He was a lovely guy. We had Rod Rosenstein one year. He worked in the Trump administration. I think we're going to get someone next year, and it's not that easy. There are not that many. I mean, there really aren't. I think people don't understand that, my board is yelling, what's wrong with you? I'm saying, what do you want me to do? Most faculty members and most people who write on the court are liberal Democrats. So here this question is that speaks to this idea, because the 6 justices on the Supreme Court would be very offended if they heard this. What is the strongest argument that this court's opinions are rooted in genuine legal theory and not just rooted in what is most politically advantageous to Trump?
Well, I think I must start by saying it's not true that there are not conservative law professors. The whole mission of the National Constitution Center is to bring together liberals and conservatives every week.
And that's why you're here.
And it's so inspiring. I do this weekly podcast called We the People, and we just have to get a conservative and a liberal. And there are very thoughtful people on all sides of all of these cases. And sometimes they agree unexpectedly. I found out that the tariffs were likely to get struck down several months ago when the head of the Conservative Federalist Society and the leading liberal administrative law guy both made Neal's argument and said, we're just reading the statute, these things are going to fall. Other times they disagree. So I just think it's very important in this polarized time to take the time to listen to arguments on both sides. And the answer to the question, are there good arguments to what the court is doing? Well, read the opinions. You can do it yourself. You're all Supreme Court geeks and junkies and lovers of history. You're here. And we're living in this marvelous age when all the decisions are immediately online. We can listen to the oral arguments, read the majority opinions and the dissents, and make up your own minds. At the Constitution Center, we do classes for kids starting in middle school. And I always tell them, read the majority opinions and the dissents. And this kid put in the Zoom, I'm Bill, I'm 11, I'm not sure I can read the dissents. And I'm like, I know you can do it. And everyone can, and you can do it, and it's so inspiring. And you're not going to agree. Sometimes you'll be more persuaded by the majority, sometimes by the dissent. But these are opinions that are being made in good faith. They're taking the time to argue them passionately. And all we need to do is read them and decide for ourselves.
And I would say,
quickly, oh, sorry.
Go ahead.
I was just going to say, among the 6, the one who I actually most take at her word is Barrett. I think that you can absolutely read these opinions from the conservatives as coming from a place of good faith. And I think that among the 6, she really is the one who tries the most to get it right and be fair. Though she's operating from perspective, but she does, I think, try very hard to be fair.
So, a plug for Georgetown. Actually, our Federalist Society had debates every week throughout the year on all the hot issues with one conservative and one liberal. So, I think that's something that, is doable. I also think, every year we look at the court, and I think, Justice Barrett, I think, really tries, and I find her very thoughtful. I think the Chief Justice is as well, and I think, that there are also decisions that are surprising and just show that they take the law seriously. The Bondi case about weapons. I don't think Gorsuch was, I really want to come down hard on these guns, but I think he thought this is the way the law should be. So, so those
Neal,
are cases that I think are important to focus
Neal,
on.
you appear before them.
Yeah, so I mean, when I'm there, I really do think they're not trying to mail it in or try and give their vote to the political party that they prefer at all. And there's many recent examples. All the times in 2020 they voted against Trump in the election, his 63 different lawsuits. I argued a case 2 years ago called Moore versus Harper, which if we had lost and everyone thought we were going to lose, would have entrenched Republican control over presidential elections for 40 years, but we won it 6-3. So I think there's examples of this. I think what's going on is that the Supreme Court is, let's face it, far more conservative than where the country is. They overturned, the Roe versus Wade. They've done, they've struck down affirmative action. They've done the decisions we've talking about. That's not because I think they're like acting politically. It's because they happen to be more conservative and put on by presidents who had that agenda, and they're following they're following their conscience, and this is the result of it. So I think we've lost in this discussion. They're accused of being political. I think, one of the great things, and you started this thing by saying, look, many of us are Supreme Court geeks. We're fascinated by the court, and that's because the court does something that models great behavior when it's done right, which is respectful disagreement, debate from one another, learning, and resolving our differences through words and not through fighting. The court's still doing some of that, but a little bit less, and so my hope is that there's more of a narrative, then the court comes back to its center. If it doesn't, I'm writing a fictional TV show about the Supreme Court with John Mulaney, which will do this. But we're hoping that in reality, this is going to happen.
It's great having Neal having the last word, but there's got to be one last word before that last word is your CLE code. In order to find your ending code, are you ready? Is HTZ987, HTZ987. This was just awesome. I want to thank Jeffrey Rosen, Tiffany Graham, Neal Katyal, Billy Treanor. Thank you all. See you next year. Come back to the 92nd Street Y and the FOLCS. Thank you.